Certainly a pleasure to be with you this morning. We've got an excellent panel on the False Claims Act. I think, as most people here know, there is an increasing intersection between criminal law and federal False Claims Act litigation, certainly. But let me go ahead and introduce the panel members to get us started. To the far end, we have Chris Rohn, who is with PwC. Chris is a partner in PwC's advisory forensic services practice based out of Chicago, and he leads the PwC forensic health sector efforts nationally. He's supported outside counsel and in-house counsel in a variety of investigations and disputes associated with contractual and regulatory issues. These projects include analysis of large volumes of financial, operational, and reimbursement data to support investigations and disputes associated with false claims actions. Chris also has an extensive experience supporting investigations into Medicare, Medicaid, and commercial insurance billing and reimbursement issues. I next want to introduce to my immediate left Chris Grippa. Chris is a partner with EY. He specializes in advising clients on complex matters involving compliance, investigations, and disputes. He's assisted clients by identifying accounting improprieties and fraudulent transactions, alleged, of course, tracing funds, interviewing witnesses, analyzing computer forensics, assessing compliance programs, reconstructing and restating financial statements. He's provided advice and presented findings to counsel, boards of directors, management, and government regulators. He has also provided expert testimony in depositions, evidentiary hearings, and a trial in both state and federal court, as well as arbitration. We also have two very well-known attorneys on the panel this morning. I'll start with Katie McDermott. I told Katie this morning, I said, I know your background well, and I've left your bio on the floor of my hotel room, so I'll do it from memory, because Katie is certainly well recognized nationally in the area of False Claims Act litigation. She's a former federal prosecutor. She's a partner with Morgan, Lewis, and Bacchius in their DC office, although I think, from what I understand, Katie, you spend probably 80% of each month in some other part of the country, heavily in False Claims Act litigation, much of it in the healthcare arena, which is, of course, where much of the False Claims Act litigation lies. To Katie's left is Bill Nettles. Bill's most immediate background is as the United States Attorney in the District of South Carolina, where he served for, I think, 5 or 6 years, Bill, as I recall. Bill has a real varied background as an attorney. He's handled virtually everything. Quite frankly, I learned a lot this morning at our breakfast meeting. I thought we ought to just come in and pick up where we left off at breakfast, perhaps. But Bill was a public defender for a number of years. He's been in private practice in other capacities. He is now out doing a variety of litigation work, but he's also representing relators in False Claims Act litigation. So we thought this would be a good mix for this panel discussion. You know, talking to Bill this morning, and I may have shared this story before, but it reminds me of a story. When you come out of government service, and many of you here have been federal or state prosecutors at some point in your past, and I think we have current prosecutors here, and maybe you'll all appreciate this, but I practiced a long time in the U.S. Attorney's Office with a very, very able assistant U.S. attorney by the name of Joe McClane, and Joe was the head of OSADEF for years. I think he was in the U.S. Attorney's Office 30 years before he retired. And Joe went out and he decided to hang a shingle. Some of you may know a very good criminal defense lawyer in Birmingham by the name of Tommy Spina. And Tommy did a good bit of large-scale kind of drug defense work. And he was dying to get Joe involved in some of these cases. So he pulled Joe in as a newly out in the private sector from the public sector, and they sat down with a client, and the client told his story, and at the end of this fact interview, Joe leaned over the table and he said, you've done some very bad things and you're going to prison a long time. Tommy said, time out, we're going to take a little break. He takes Joe out in the hall. He says, Joe, what are you doing? You're not a prosecutor. He goes, I know, but this guy's guilty, you know that, and I just can't tolerate that. And Tommy said, you're going to have to be able to make this move. You got to let him down easy. We're going to have to plead this guy out, but don't handle it that way anymore. So next client comes in, same thing. Tommy swears it's true story, and Joe confirms it. He hears him, listens, reflects, leans over the table, and he said, prison's not that bad. It can be a slow transition. I'm not sure where Bill is in this transition at this point, but we're certainly pleased to have Bill on the panel. Some of the topics, well, let me give just a quick overview. Let me get a show of hands if I could. I know we have perhaps predominantly criminal defense lawyers, but how many of you have been involved in False Claims Act cases and litigation? Okay, well, good. And that doesn't surprise me with the parallel nature of these cases, but certainly the False Claims Act has become the DOJ's favorite civil tool for pursuing large damages and civil monetary penalties in cases of alleged fraud against the government, as well as in getting corporate integrity agreements imposed. The theories of liability have certainly broadened in recent years with increased pursuit of cases based on differences in judgment, use of statistical sampling, and extrapolation to infer both damages as well as liability. And now we have the Yates memo that is going to be on a different panel. We won't get into much here, but it expressly cross-references the False Claims Act. And of course, everyone's wondering, what will this new administration under the leadership of Attorney General Jeff Sessions do in this area of False Claims Act litigation, as well as, of course, in criminal law. Basic elements, with the show of hands, I won't spend much time on this, but there has to be, of course, a false or fraudulent claim, which has to have been presented or caused to be presented for payment, and with knowledge that the claim was false. And of course, under the False Claims Act, knowledge is defined broadly, not only to be specific intent, but to include acting in reckless disregard of the falsity, which, quite frankly, in my experience, is where most of these cases lie, not in actual proof of actual fraud, but in reckless disregard. And now, in addition, it's clear that falsity has to be material to the decision to pay the claim. Damages, enormous exposure, potentially trouble damages. Civil monetary penalties have been increased to a range of $11,000 per claim to as much as $21,563 per claim. And on top of that, the statute provides for statutory attorney's fees and costs. This has been much used, as everyone here knows. It's increasingly used. The statute, over $4.7 billion recovered last year, fiscal year 2016. $2.5 billion of that in the healthcare area. Seventh year in a row that recoveries have exceeded $3 billion. And the total recoveries under the False Claims Act since January of 2009 have been in excess of $31 billion. $24 billion of that attributable to key TAM lawsuits, and Bill, that's good news.
Oh, yeah.
Yeah.
I want a little piece of that.
Some of the issues we want to talk about, and kind of what I refer to as some of the hot topics currently, and we'll go beyond that, include the issue of materiality, the Escobar case, and would the alleged violation have impacted the payment decision? What I refer to as mere differences of medical judgment. That's my AseraCare hospice case that we did argue on March 16th, still awaiting opinion, as Brian said. We'll talk about that a little bit. I can't talk much about it, but I'll give some context to the historical procedures in it. The issue of whether or not a reasonable interpretation of ambiguous guidance from the government is a defense. The courts, including the 11th Circuit, have been a bit all over the map on that. And then, of course, the issue of statistical sampling. So first, what I'd like to do is turn to the Escobar materiality issue, because that opinion was handed down by the Supreme Court back in June of 2016. And interestingly, at least my observation is following the opinion, both the Department of Justice and the defense bar more or less proclaimed victory, saying it really supported their positions. I'd like to turn first, Katie, to you, if you would, if you could give some perspective, quick background on Escobar for those who are not familiar with it, and then give your thoughts on whether there's clarity or confusion at this point in the courts.
Okay, terrific. Good morning, everyone. I don't know if there's clarity or confusion or if we could ever answer that in False Claims Act litigation, but let's talk a little bit about Escobar, which some folks think are a game changer for handling False Claims Act cases on all sides, government, relator, and defense. And Escobar is a really interesting case because it presents, I think, the epitome of the dispute about whether the False Claims Act can be used for regulatory violations, as opposed to more traditional fraud, when you have an improper code or you forge a signature, the classic badges of fraud. And False Claims Act litigation, particularly since the 2009 and 2010 amendments, is very much broadened, both procedurally. The changes have allowed broader suits, and also the theories. And so I think this really came to a head in the Escobar case, which was a case out of Massachusetts where a teenager died of a reaction or had a seizure to a drug reaction. And it turns out that the care that the teenager was receiving from the mental health entity clinic didn't have the correct licensed personnel, and also didn't have the proper supervision of prescribing practices. And it's a little more complicated than that, but that's the rub of it. And the Massachusetts state regulations required a level of qualified personnel, and this is very common in healthcare. It's very common in Medicare. And by the way, it wasn't a Medicare case, it was Medicaid. So somehow they got themselves into this argument over whether there was falsity in the submission of claims to a federal healthcare program, and whether the unqualified personnel and unqualified services were somehow an implied falsity. And this, to me, is just one of these really great quagmires of the law, arguing about whether fraud is implied or expressed, whether it's a condition of payment or a condition of participation in a healthcare program. And because the jurisdictions over the last 10 or 15 years have really tried to grapple with the nature of fraud, particularly in complex fraud schemes, you started to have really very chaotic jurisprudence on and unpredictable decisions on whether conduct could be actionable under the False Claims Act. And this rubs up against the general precedent that the False Claims Act isn't a general fraud statute, that every wrongdoing is not actionable under the False Claims Act. As Jack just said, you've got to have a false claim presented to the government for payment, or you've got to have a false statement in support of a false claim for payment. So I do a lot of these cases in healthcare where the regulatory scheme is complicated, and a lot of the legal theories would say, well, if you didn't provide good quality care in the hospital or nursing home, the government didn't get the benefit of their bargain, and that's a fraud, even though the claim may not be false itself. So you'd have to look to the underlying services to try to find the fraudulent conduct. So then the courts have gotten into trying to define legal falsity versus factual falsity. Are you confused? So we're not going to get into all that now, because Justice Thomas issued, I think, an excellent decision in Escobar, where he said, look, we're not going to do all these labels of implied certification or express certification. We're going to look at actionable misrepresentations. And this is really interesting opinion. It's a very short opinion. It was 8-0 in the Supreme Court. And the oral argument before the court was fascinating because it was completely incoherent from the defense side and the government side, and I don't remember what the relator said in connection with the case, but it just shows that there's a lot of gimmickry and artificial legal analysis occurring, and I think the Supreme Court was just cutting through it and saying, we're not going to use these labels. We'll recognize implied certification in some instances, really implying that it's narrowed, where there's actionable misrepresentations that go to the qualification for payment. And they can be omissions. So you can fail to disclose. And in Escobar, they seem to have set up the case as a failure to disclose that the personnel and the services were unqualified. In my opinion, it was never an implied certification case because they didn't meet the requirement for payment. And the Supreme Court decision illustrates that well by going through and explaining, like the other decisions didn't, or the briefs, that there were payment codes associated with how the claim was submitted. So, for example, there's a payment code for the service they provided, so if it's an unqualified service, then the payment code is wrong. There was a coding for the title of the person. So if you coded it to a doctor, but a doctor wasn't prescribing or supervising the prescription of the drug, then that was false. And I think the decision does a really good job of linking the falsity to the qualification for payment. And to me, it would just be a plain old False Claims Act case in that sense. But so the court basically recognized the theory, but cabined it in connection with actionable misrepresentations. Then the court went down the line, in the opinion, to address a lot of concerns that folks have raised about the chaotic nature of False Claims Act practice, where you have this punitive galactical, liability and criminal and administrative and all the things that go with it. And it really took on the concerns about recognizing implied certification as a theory of liability. And the court said, don't worry, because the materiality standard is demanding. And when I read that for the first time, I thought, yeah, right. The government's just the relators are just going to write, it's all material, because in the conference room, they say everything's material, right? So they'll just plead materiality in a sentence or two. Well, that's not what's happening. The trial courts are really saying, the Supreme Court said the materiality standard is demanding, therefore it is demanding. And the government complaints have been dismissed, relator complaints have been dismissed, some have not. But there's clearly the lower courts are trying to apply this concept of a demanding materiality standard. And the court also mentioned scienter, and materiality and scienter has to be pled well. So where I think we are in this, the court said a couple of other things as well. It said it's not a general fraud statute, and it was very clear that regulatory violations are not going to sustain False Claims Act liability. And the court went on to explain that it wasn't its intention to open the door to those types of theories. And I'm going to talk about two cases related to regulatory violations that address that. And the other thing the court said that was very interesting, when it was talking about materiality, it had a more objective perspective to it, because the court explained, and the lower courts have done a great job of fleshing this out, it's not that the government could refuse payment if it knew of the noncompliance or the fraudulent misrepresentation. It's whether they're actually doing that or would do that. So that's really shifted the battle to developing information about what the client agency is doing about this so-called fraud scheme. So I think what's happening now is the client agencies, who are, I think, sometimes not a player in the government's, the DOJ's assessment of liability for pursuing these cases, is now a much bigger player. So, for example, if CMS continues to pay the claim, or in a nursing home, if they do a plan of correction instead of shutting off the money, that's going to be evidence of a lack of materiality. Whereas before, I don't think the courts or even the government would have accepted those types of agency action or inaction as evidence of anything. So I think it's really shifted the questions and the approach. And there's two cases I think that are really interesting that illustrate this. One is the Augustino case in the First Circuit where Escobar came from. And many of you, I know many of you, have handled these fraud on the FDA cases, the off-label marketing and the misbranding. There have literally been billions of dollars paid under this theory and by corporations. And I always say the False Claims Act is more about lore than law because a lot of the precedent is in the conference room. It's not in the courtroom. Hopefully that'll be changing. But as a practical matter, there's been a lot of settlements under this theory. And this theory in a medical device case in the First Circuit came up against D'Augustine versus EV3 and some other device companies as to whether they had made misrepresentations to the FDA in the 510K clearance process to get their device on the market. And the representations related to physician training and safety. So those are great optic issues, right? And they allege there were regulatory violations in this process and non-disclosures. And the First Circuit said, we're not going to recognize that as a viable False Claims Act theory. And this is really big. And they indicated that in terms of applying Escobar to a regulatory violation, the court noted that CMS continued to pay the claims and had taken no position on payment for the device. And we know that happens in off-label every day. If it's a cancer drug or an HIV drug or spine, these areas of off-label use by the physicians, CMS has been paying the claims. I had the biliary stent case. That's a whole industry around an indication that only is 11,000 cases a year, and it's millions of cases where stenting occurs. So we know that the off-label occurs a great deal when it's medically necessary and reasonable, and that CMS has been paying. So what the First Circuit said is, if CMS is paying, then that is good evidence that whatever the non-compliance is immaterial or not material. It then focused on FDA. This is the part I like best in the opinion, where it said FDA hasn't recalled the product. This is all public information you can put in your motion to dismiss. They haven't recalled the product and they haven't required relabeling. So the two agencies, client agencies that should care about this alleged regulatory violation, this so-called fraud, don't care about it. And so therefore, we're not going to presume materiality. And you can't get, they denied the ability to amend the complaint and move forward. And I think this is very important because if you look at the expansion of the False Claims Act and where this $4 billion comes from, it's largely from these regulatory violation ideas. And I think that Escobar really presents us with a different analysis for those types of allegations. And there's another case in the Third Circuit, Dr. Reddy, which I thought was really interesting, where it was alleged that the manufacturer did not comply with regulations on child-resistant packaging. This is just pure FDA regulating of safety and packaging, labeling, and distribution. And the court there found there wasn't a connection, a causal connection, that showed any kind of materiality related to the False Claims Act. So it was dismissed. So they declined to endorse implied certification in both of those cases. So I'm shortcutting Dr. Reddy a little bit, but it's definitely worth reading because it seems to be that's where the courts are going with this materiality idea. So when the Supreme Court said it was demanding, it seems like, yes, it is demanding, and they're really looking at it. The other thing that Justice Thomas said in this opinion is that the issue of materiality can be resolved in a dispositive motion. So it is appropriate to challenge the sufficiency of materiality at the motion to dismiss and later in the motion to summary judgment stage. So I think that's why we're seeing a lot more motions talking about materiality.
Katie, thank you. And Bill, again, you most recently out of the U.S. Attorney's Office handling these. I know you expanded the False Claims Act group within your district of South Carolina significantly. You're now representing whistleblowers amongst others. Do you agree with Katie's assessment? Is this really a significant change or in the standards or how you deal with motions to dismiss or actually how you prepare your
It really
complaints?
is pretty interesting because, I mean, it's classic, right? Because on the one hand, when that opinion came out, the relators bar was just ecstatic about it. I mean, just absolutely ecstatic about it. And I think you're right in that I don't think that it expanded materiality like they thought it would. But I do still I agree with her that what the relators bar thought was going to be really just like the most amazing thing ever. And then when you really start digging down on it, I agree with your analysis on materiality. And I will say too, we always felt like, CMS was a little bit different because they're like mainly data, but anytime, I always felt like you had a real tough row to hoe, even before Escobar, in situations where, like, the relator would bring you a case and just pick an alphabet agency, right? That you're going to get your OIG to do the investigation. And if they looked at it, and if you couldn't get them excited, I mean, I was kind of like, look, this is going to be kind of tough, because if at some point they started to depose them, and they're like, yeah, they came to talk to us, and we just didn't really see anything there, and we didn't really care. And you ran into that a lot because we would see a fair number of. One of the few things that we do have going for us in terms of industry in South Carolina is defense, right? And so, we would see a lot of defense cases where they'd be like, yeah, okay, they kind of lied to us, but we really don't care. And you know what I mean? I mean, that's a little bit more complicated.
Yeah, no,
that's sort of the gist you got, right?
The client not supporting the case.
And the relators counsel, I think we can get around that. And I'd be like, man, good luck. Because, at some point there's going to be discovery. And if you've got people from the agency that's supposed to be really caring about this kind of going, okay, look, we're doing this little wink and nod thing, and everything's good, and, everybody's safe, everything's fine. And so, I mean, even before, smart people like you started, really looking at this, I was like, look, if that agency's not behind you, you got a problem. I mean, you got a real problem. You got to get all the experts you want to flying from out of town, but it's not going to be a good case. And so I think that sort of crystallized a lot of that.
Yeah, I think it's going to be interesting because if you look at the government's discovery responses in False Claims Act cases, it's like there's 5 pages of objections on deliberative privilege and all this stuff that I don't really remember anymore. And it's never any facts about the agency view. And I'll talk about a Sarah Care, Jack can, but that was fascinating in the trial when this agency witness from CMS, and I was getting live transcript at the time,
Katie Lucas.
Yeah, did not agree with the government's theory.
Yeah, that's right.
And guess what? They didn't learn that for the first time at trial. They knew that all along.
That's right.
So as a practical matter, there's going to be a real push to get the agency information, and there's going to be a pushback claiming privilege this, privilege that. And the courts will have to figure it all out to make sure there's fair trials, and I'm sure that'll happen. But I do think if you look at these cases from the First Circuit and the Third Circuit and Escobar, they're really saying, well, what is the client agency's position? Did they recall? Did they stop payment? Did they relabel? Did they invoke their administrative scheme, which they all have the power to do if these violations are material?
But can I just, on that saying, but I mean, and I'm just asking you. I don't have an opinion on this, but
I'm sure I do.
Yeah, no, I'm sure you do too, and I'm interested in hearing it. But I mean, my experience was like the agencies could move really slow, and like I kind of got the sense that I'm not talking about the OIGs and stuff. I'm not talking about all that kind of stuff, but I'm talking about they could sometimes move really slow and almost like they were waiting to see what happened with the case, So I am a little bit worried. I mean, I think it's relevant, and I think I think it. I would just like for it not to be determinative. In other words, so like if FDA doesn't stop it right away, I don't think that's, I would feel more comfortable, not just because I'm trying to make some money off all this, but that I would like to feel that, that would just be a factor to be determined. I mean, to be considered, I guess.
Yeah.
Bill, I'm continuing to look for the sort of agent you've described who's unenthusiastic, and I'm not running into them, but it may be the stage at which I get at that point.
Well, I could give you some names.
Well, let me add before we leave Escobar, and it will probably be woven back into the discussion throughout the panel. But Katie, you were mentioning, and Bill, I think you did, discovery. I mean, typically in these cases, as all of you know, the discovery is all coming out of your client. It's under CIDs, perhaps for years. You produce millions of pages of documents. The government has that unilateral power. Congress gave them under the CID provisions of the False Claims Act. Now with the materiality burden clarified, if you will, by the Supreme Court, what are the discovery opportunities and what sort of evidence should a defendant be seeking from the government, from the Department of Justice, from the agency at issue like CMS in the Medicare context, from the Medicare contractor itself? And some of this has been ongoing publicly in the ManorCare case, where the government has pushed back on discovery efforts by the defendants. Where do you see that going, and what could be a benefit to the defense attorneys here in litigating those cases in terms of how they handle discovery?
Yeah. Well, I think if you're in the investigation phase, the obligation to preserve records is on the government. And that's important because some of these agencies, particularly the FDA, have a lot of internal communications. They have a lot of external communications, and you want to make sure those are preserved and you can get those. And I anticipate and have issued subpoenas to Medicare contractors. You've got to follow the TUI regs when you're trying to get documents from the government and testimony. So there's a lot of complication to the discovery process. You have to go through a lot of hoops. But I think you have to be very aggressive in pursuing it, particularly where there's a third party like a contractor or a ZPIC involved. They have a lot of interesting things in email, I have found. I also have made heavy use of FOIA. And I used FOIA in litigation, and what I've gotten from one discovery response is sometimes different from the FOIA response. And that's not because necessarily the government's playing games, but the government's very big and complicated, and they may have only asked one person for records and the FOIA person may have asked someone else. I don't know why there's discrepancies sometimes, but I don't think it's malicious or intentional. But I would cover my bases. And I think you've got to get that information. Where the government's really pushed back is when we try to get information on how they've treated other providers. Have they allowed claims? What have the audits been? What are the ALJ decisions? We do Jack does a lot of hospice. We're all doing a lot of hospice work right now. I mean, the Medicare contractors are night and day from the East Coast to the West Coast on their determinations, on their standards, even on their written guidance. It's absurd. But we put together that absurdity, and that takes some time to do, and the government does oppose that. But if you're a provider, particularly with national operations, and you're trying to comply with the so-called Medicare guidance and regs, it's really hard to do when they say different things in different parts of the country. So you have to work through all that, and that is a Herculean task on the defense side in putting that together.
Let me shift to statistical sampling and extrapolation, because that's a huge issue in these cases, particularly in the healthcare related cases. Government will pull a statistically valid random sample. They will have their expert go through those, come to opinions about whether or not the claim was appropriate based on the medical records. And typically will then summon you in, you sit down, you get a dog and pony show, so to speak, shock and awe, I call it. And they may illustrate 5 to 10 patients and say, now this applies to thousands, and therefore the damages are $100 million or whatever the number may be. Interestingly to me, Bill, as the former U.S. Attorney in South Carolina, was in the Agape case as the U.S. Attorney. And is now out after that opinion, which I'll get you to go into a little bit, They have just settled that case when it came back to the district court level. I think the relators originally had settled it, reached a settlement agreement for about $2.5 million. They ultimately, the government was paid $250,000. But let's talk for a minute about the use of statistical sampling in these False Claims Act cases, where in my experience, the inferred damages, if you will, the extrapolated damages, typically make up over 95% of all claimed damages. So it's really where the heart of the exposure lies. And let me turn first to Chris in terms of how you get involved in statistical sampling issues, and maybe explain how this sampling works.
So one of the things we get in,
I think it works really well. I'm a fan, okay?
one of the areas we get involved in the statistical sampling is, the overall population. So a lot of that comes back to the quality of the data. To be able to do this statistical sampling on top of the data, you have to have good quality data. And then the other area that we get involved in, and a lot of times it's people who are not me, but statistical experts that can provide expert testimony as it relates to how well represented the overall population is based on, how they took their samples. And this is province stat type, complicated analyses. And, it requires a lot of professional judgment in preparing these samples.
And I guess, what I would add is the data involved in these matters and how, the government has more and more access in almost a real-time basis now between Medicare data, Medicaid data, other data feeds, where for the targeting and identification of the investigations, it's coming real time. And, they might find an outlier, then do a CID, ask for a lot of data from the company. The company turns that over. Many times what we see in statistical sampling cases are they might have pulled a sample for one reason and are trying to draw conclusions for another reason. And you need to make sure that both the population that's polled as well as the reason for the sampling exercise itself, are appropriate. And, the math doesn't work if you pulled the sample for one reason but are drawing conclusions for another. I think, some of the questions that have come up, as we talked about materiality and Escobar and other things, are raising the question of moving up in the order where some of these things need to be done in the course of investigation. Because these conclusions are drawn based on, productions, some of the processes that Chris mentioned of, doing reconciliations to make sure you're turning over the right data, making sure that population, is inclusive or exclusive of the appropriate transactions. So many conclusions are being drawn early on in investigations and in matters that it can really impact you, as most of these come through settlement, where you start in that settlement process or discussion. So, we're spending a lot of time with data cleansing efforts, making sure the right populations are there, and then the sampling techniques that are used are appropriate.
Here's the issue that I've seen, and I know that Bill and Katie have seen in both of you guys as well. In the healthcare context, you get, if you have a company, a healthcare provider that's nationwide, what the government will do is pull the sample, and a big issue is historically, what the government will say is, well, statistics is a recognized science, and it is. And if used appropriately, it's a reliable basis upon which to infer to a larger population. We know that from statistics, and that's as far as my statistics go, by the way. But there's been a distinction between inferring damages when liability is established versus inferring liability. So here's the situation that I've seen played out a number of times. You get a national healthcare provider, and let's take a hospice context. You have a patient, grandma in one part of the country, where the government expert comes in and says, look, the medical record doesn't really support that she was likely to die in the next 6 months, which is the regulatory, the legal standard. And we can take that example, and that clinician, that doctor who made that call and certified the patient was terminally ill was simply wrong. And we can take that patient and we can infer to Pennsylvania with a different patient in a different circumstance and a different doctor, and they don't know each other and they've never communicated. We can infer that that doctor was wrong as well. So they're now moving to extrapolating out to liability as well. And some of the big cases, and I'll ask Bill and Katie about, we had the life care case in Chattanooga, Judge Matisse, who issued a lengthy opinion about statistical sampling and extrapolation. At the end of it said, well, this is really a jury question. Case then settled at some point thereafter. And then we have, think of Agape, Bill, your case.
What about the case? Yeah.
Well, you were involved. The case in your district where it got kicked back, and ultimately the judge said the decisions are too individualized on these patients. You can't extrapolate, at least on liability. And then another case comes to mind, the VistaCare case out in Dallas. Judge Barbara Lynn said, can't do it in this context.
Yeah.
What are your thoughts about that issue of extrapolating to liability and where the case law really is, and have any circuit courts yet issued opinions in that area?
Well, Agape, the Fourth Circuit declined to get into the issue of statistical sampling. So that was maybe helpful. I kind of liked it that they didn't get into it. There's a reason Mark Twain says there's lies, damn lies, and statistics, because it's fundamentally manipulated evidence. And we've all worked with experts a lot, and the government will cherry pick their line of sample. We'll want to have a broader sample. They'll want to have a more narrow sample. And, you can find a statistician to say just about anything, is what I'm learning about statistics. But stay away from the statistician that says I can extrapolate anything. Just absolutely stay away from those types. The ego of the statistician is hard to work with because it is really complicated. And I think in the hospice cases, you have CMS and the medical community saying death is an inexact science. And then you have the statistician saying, well, these people live too long. They shouldn't have had care so long. It's just fundamentally ridiculous. And I think that's why people are chafing against using the statistical sampling in certain types of healthcare cases, where the medical condition and the medical judgment has always been viewed as more art than science. So in that context, it can be very troubling. I think that you have to really spend a lot of time on this. I don't like it. It's like when I went to college and statistics, I hated it. Remember coding and computers, and then we had e-data. I mean, it's terrible. I should retire because everything is so complicated now. But we really have to grapple with it early on. And I'm not sure we should be that afraid of it. If we accept that it's manipulated evidence, we'll get in there and start manipulating. What are you going to do? Because it's anyone's judgment or call, it seems like, in terms of how it's going to be approached. And the thing that's interesting about the life care decision, which everyone was very upset about, it seemed like, except the government maybe and the relators bar, is the judge said the sampling could go to liability and damages. I'm not sure how I've figured that out yet, whether they're different or maybe they're just the same, because I think that's very interesting, the way the judge characterized it. But the one thing that the court decision did say, which I thought was terrific, it said you can impeach the sample by any means. So instead of cabining it to just, the experts of the statistician, I read that to mean the sample can be impeached. So if the clinician says not eligible and the certifying doctor says eligible and another expert says eligible, that sample is tainted. I don't know how you're going to extrapolate it. So I actually view life care as somewhat of a favorable defense decision because the judge made it clear that you have really a universe of impeachable opportunities to the sample. It's not going to be just the science. The other issue on the sample, again, if I'm reading this case correctly, and it remains to be seen, is that you can also attack the sample if it goes to liability on the core issue of falsity. And I think, Jack can't talk about hysteric here, but I will. I thought it was really interesting that the falsity, the so-called false conduct, was never linked to the sample and couldn't be linked even when the government was given an opportunity to do so. That's why they lost the summary judgment, because they couldn't show the evidence on the sample. So what I'm taking from all these cases is pay very close attention to the sample. Don't limit yourself to just statistical opinions about the sample, but go at it. Get to the physician that certified the care. The whole government's medical necessity strategy is to ignore the doctor, because doctors have jury appeal. And so they'll get an expert from Omaha to say that somebody in Florida shouldn't have been on hospice for 6 months longer than they were. And that's a pretty boring case, in my opinion, but that's what the cases are. But they'll never talk to the doctor in Florida who certified the patient. They just want to eliminate the doctor. So if you're developing your sample with your experts, interview the nurse, find the IDT minutes, interview the doctor. Do you remember Mary Smith? Yes, I do. She was terminal every time I evaluated her. Okay, bingo. I don't even think you need another expert if you can get that. But I would take the life care decision and run with it and develop that impeachment evidence on the sample. And that's what all I can think of. The one thing that's really interesting, because I grew up in the 90s in the False Claims Act work when I was a baby lawyer in the U.S. Attorney's Office, and I always understood you could extrapolate if you had uniformity. And a lot of the early extrapolation cases, which I don't see cited much anymore, dealt with labs or coding. If you had one bad code and you had 1 million lab requisition forms that are identical, you could predict with reliability that this bad code would be on, 1 million forms. And that's what the courts were worried about and trying to judicially manage the trial. When you get into sort of hospice and the medical necessity arena, you don't have uniformity. So I'm not sure why it's okay to extrapolate. We extrapolate for consumer information, we extrapolate for demographics, we have actuarial extrapolations, all that can be challenged. But why in a fraud case, when you're dealing with death, the agency has said is an inexact science, is it okay to extrapolate? And that's what I wish the Fourth Circuit would have addressed if they could get to it. They couldn't get to it procedurally. And that's what we're fighting about in the conference room and in the courtroom on sampling.
Chris.
And I think along those lines, sampling is a big cost saver. We can take this sample, we don't have to review.
Well, not if you get a $400 million judgment.
Well, that's what I'm saying.
You save you a darn thing.
Up front, you're trying to save money. With the tools today, and it's the right tool for the right job, you can actually get to more sophisticated data analytics and look at behind the sample and look at the population analysis to help carve out, the example you used earlier of this part of the country has one set of guidance, this part has a different set of guidance. Perfect example to blow a hole in their sampling methodology.
Yeah.
So the problem is it is expensive up front to do that analysis, but it will pay off later, in my personal opinion. So, the new tools and techniques we have to do data analytics beyond sampling, can help in these arguments and help in those settlement discussions.
Yeah. Rule 1 is to oppose extrapolation. And that's always rule 1 if you're on the defense side. I also think these cases are good for bellwethers because the government or the relator will put up 5 examples and want $500 million. What? Let's see if the 5 pan out before we go to expensive litigation and extrapolating. Let's see if you can prove your 5. And I really think the court should be allowing that because these are quagmires that go on for 3, 4, 5 years after intervention, costing millions and millions of dollars. And can they prove the 5 that they have in the complaint? And I litigated one where they couldn't. So, let's start small and go big, not just presume, the quagmire.
Bill, you had a comment, I think.
Yeah, that Agape case was a complicated case. I mean, there was just a lot going on there. I mean, and the hospice cases as a whole are, it's kind of weird, right? I mean, most of the false claims, I mean, not, but like like when I was doing some wrongful death stuff, I mean, the person died, right? And so now the question is, why did that person die? And so now it's almost, I mean, the hospice stuff is different. Like, they didn't die, and why did you bill us like they were, you know? And so you got all that uncertainty. You know, you can't really, fortunately, you can't, for most cases, pick when somebody's going to die. So there's a whole bunch of uncertainty there. And then you wanted to try to do statistical analysis on that. Now, look, I think statistical analysis is somewhat like playing a guitar and a harmonica at the same time. I mean, it's just really hard, you know? And so, you know, but I think that, you know, the other layer on the Agape case was that case had they'd arrived at a number, but they couldn't come, and, you know, we negotiated that. They couldn't, that case settled after I'd left. It was in the throes of whenever I was there, but they couldn't come up with a scope of the release. And then and I think it was all innocently, but the defense lawyers and the relators lawyers met without the government because the government had not intervened, and then basically got this massive release, which the government would have never approved. So, I mean, you know, under the old adage that, you know, bad facts make bad law, I mean, that case just it was just a mess. It was a total mess. In terms of statistical sampling, I mean, I think it ought to be something I'd be able to done, you know, but I think that it ought to be pretty wide. And I think the courts have, by and large, encouraged, you know, they recognize that this could be something that could take a jury astray. And so, you know, I mean, really. And so, I mean, I think that the courts are going to are beginning to, and are ultimately going to say, look, y'all get real wide latitude in terms of, you know, questioning these samples, regardless of who puts them on.
You know, I can't certainly give any opinions in regard to AseraCare, but I want to ask a follow-up question on the principle, if you will, that's involved in that case that's now involved in other cases. And we'll just give a little procedural background. As a hospice case, allegation, we're certifying and providing hospice services to patients who didn't fit the definition of being terminally ill, which is essentially likely to die in the next 6 months based on a physician's opinion. Now, the guidance out there is limited. The statute basically says it comes down to a physician's opinion. The regs follow that. And then there's a sub-regulatory provision that says the information in the medical record must support that terminal prognosis. And that's really it. So there's not a great deal of guidance. So government pulled a sample. Their expert came in and said roughly half of the patients in the sample really were not terminally ill according to the medical record. And the first thing that happened procedurally, at least not the first thing, we were in discovery a long time, but as we approached trial, as we got the judge to bifurcate the case between the issue of falsity and knowledge of falsity, and it's certainly something I'd recommend if you're in one of these cases that you consider. It depends upon your particular facts. The government had, in contention interrogatories, basically stated our only evidence of falsity is the medical record and the opinion of our medical expert. So it was a fairly clean divide. She bifurcated. They tried to come in and claim, well, we have some other evidence they could never really articulate on falsity, and she said no. We went forward, tried largely the medical issue in phase one, had what I'll call generously a mixed result to a bad result. The jury found most of the patients not to be terminally ill, and therefore those claims to be false in the answers to special interrogatories. And we were beginning to go into discussion, all of which is on the record in chambers, about phase two, and the judge came in and announced that she had concluded that because she had not given certain jury instructions we asked for, that she had committed reversible error. We moved for a new trial. She granted it. The government was understandably not happy with that and expressed it. Several days later, we were back in front of the judge, and she said, you know, I've been looking at this closely, and I've concluded that the government actually did not offer any evidence proving falsity. And I'm inclined sua sponte, pursuant to Rule 56F3, and we all flip through our rule books under the table, to grant summary judgment. She had to give both sides an opportunity to brief, and then she granted summary judgment saying, on this basis, that a mere difference of medical judgments, government expert versus defense expert, is insufficient without more. Now, in AseraCare, the government medical expert in deposition and at trial reaffirmed that though his opinion was patient X was not, the record didn't support the terminal illness of the patient, that he could not say that the contrary opinion was wrong, therefore suggesting that was reasonable. He simply had a different opinion. And then there were 10 patients in the sample where he changed his opinion, most from eligible to ineligible, but some the other direction. And then he took the position under oath that he was correct to a reasonable degree of medical certainty as to both opinions, eligible and ineligible. So the judge came in and said, that's just not enough. You need to have some evidence of an objective falsehood. That's the issue on appeal before the 11th Circuit that they heard March 16th, and we're awaiting the opinion on the summary judgment ruling. But I've seen it picked up, of course, in other cases. The VistaCare case, Judge Lynn, I mentioned in Dallas, kind of piggybacked that and relied on it and said, government, you don't have any more than that. And this concept, this issue of how far can the government go merely on one expert with a differing opinion in the context of guidance that is judgment-based medically? I mean, what are your, that's an area in which I see a lot of the government's Medicare cases kind of fall in that arena.
Yeah. Well, there's actually a lot of cases. There's the Gestry case in the Northern District of Illinois, which is a really good decision explaining that mere clinical disagreement is not proof of falsity. There has to be something more. And it also can't be just mere disagreement with, and that was a hospice case, the certifying physician. And that's kind of how malpractice cases are in some jurisdictions. Unless you have a malpractice opinion, you can't move forward. And these types of cases, if you were in government putting a case together, at least how I learned to put them together, you first would determine whether coverage criteria covered the service and whether it was met. And so if there is insufficient documentation to support in the medical record to support the diagnosis, that's not proof of falsity. That's proof that the coverage criteria may not be met. That may be an overpayment. It may be a disallowance, but I don't understand conceptually how that's proof of fraud, because that's an intent-based finding. So I think it's very muddled, and if you were in an indictment review in the U.S. Attorney's Office and you were jumping to that, I don't think you'd get your indictment approved. So I don't understand how in the False Claims Act, in the conference room, I guess that works, but in the courtroom, it seems like it shouldn't be working that way. There's got to be some additional evidence to show that the disallowance or the overpayment is the result of some fraudulent conduct. And I think that's what eventually happened in this particular case, and why there's probably now about a dozen decisions. There's one in Philadelphia in the last month where the courts aren't buying clinical disagreement alone. And I do think that there's an initiative on medical necessity. Let's ignore the attending physician. Let's get some expert, a hired gun. It's almost like ambulance chasing, I think. And let's say if there's a documentation deficiency, that's automatically fraud. And again, that plays out well in the conference room for quick settlements. I'm not sure it's going to play out well in the courtroom. You've got to connect that evidence. And I think it's correct to say that clinical disagreement alone cannot be fraud. You've got to have more. And we'll see where the courts go with it.
But in that, I mean, I know those hospice cases, I mean, the more I thought about them, they're hard. I mean, from a relator standpoint, it's just a lot of moving parts. But I mean, and I hadn't thought about it as much as I should, but I mean, in that, okay, so if you've got a clinical disagreement, all right, doesn't it only become relevant if whatever the number is, you start saying, yeah, but we're always clinically disagreeing with them. I mean, isn't that where the statistics kind of starts to come in? Where if you said, look, we're cherry picking a couple of cases, but then we start looking like this broad, they've got a bunch of people. And then I think from the jury appeal standpoint that we've left out of discussion so much is they actually get more money, right? So I mean, isn't that how you start to get the jury appeal? You start saying, you've got clinical disagreement, okay, right, doctors can disagree, but they disagree about this big chunk of cases and they're getting a whole bunch of money. I mean, isn't that what makes it the jury appeal? Right? because the statistical piece comes in there, right?
Well, in hospice, Medicare's paying less if you go on hospice. That's the interesting thing. The fiscal argument doesn't work, because if they didn't go on hospice and they went to chemo or they went and got the heart transplant, they'd be costing Medicare a lot more. Medicare isn't losing money because they stay an extra 6 months on hospice. But I think it's hard to find one doctor. Most of the hospice cases have 10, 12 doctors that are certifying eligibility, and then there's one doctor that's disagreeing. And then, the defense has to bring in their expert. So, I mean, I don't know. I never thought clinical disagreement made a good fraud case, but maybe it can, because the jury did come back for the government in the AseraCare case on an erroneous jury instruction. So, but I think it's kind of like Escobar, where the Supreme Court said, let's get back to real fraud and find something that's false, find actionable misrepresentation. I don't see why that wouldn't apply unless you thought the clinical disagreement was incompetent or corrupt. Why wouldn't it be accepted?
Let me ask Chris and Chris. In the cases that I'm in, we involve experts early and often. There are a lot of different areas. The government is relying heavily now on data analysis. They can put on quite a presentation that's quite compelling to show you how your client is an outlier and those sorts of things. What are the sorts of things that both of you and your companies offer in terms, and how do you get involved in these cases, from investigation through negotiated settlement or even trial?
Please.
There's a host of issues. Fact-finding and data gathering is probably one of the biggest roles we play in a lot of these matters. And I think there's a continuum from, helping an organization that just received a CID, how do they gather the information, document, to there's an actual knowledge of a specific investigation, what really happened, what took place, how do you gather the data, how do you manage the e-discovery through, actual, potential damages, calculations, sampling efforts, a wide range. What's been interesting lately is just the use of data by the government, DOJ, FBI, and others in these matters. And then now, in some cases, we saw with the Forest Park case and others where they're going beyond just traditional False Claims Act and government claims, but starting to use things like the Travel Act and, commercial bribery statutes to bring in, at least in the healthcare space, commercial claims as well. So it's a whole new area of theory and really expands the scope of some of these investigations. So, we help in a lot of different matters at different points. What I will say is the impact we can make is earlier. Now, it can be expensive to do that investment up front, but, in those situations, we can typically add the most value downstream. Chris?
Yeah, I'll just pile on. I think Chris's comments are fantastic. And, ultimately, when you're looking at these types of cases, the language of business is the accounting records, right? So, it can turn on the data behind those records. So applying data analytics on the accounting records is critical. Same thing with e-discovery. The advancements in e-discovery these days, things can get quite sophisticated, and we're seeing, just to take it out of the e-discovery world, just more generically, autonomous cars that are taking data inputs from a variety, from video cameras, from GPS, from all these different things, and essentially extrapolating where you go. So it's a fascinating concept. I don't know that, the application is well served on a consulting basis, and, can help direct certain aspects of, where to focus the fact finding and be able to find facts quicker and better, which is important in these types of cases. Some other thoughts is firms like EY, we get involved in the settlement discussions. So, we help and provide information to counsel. So when they're going to discuss settlement, they have, transactional-based information that they can, have a rationale behind what they're proposing. We also do, research on previous settlements and gather all that information. The firm has, incredible resources to gather that types of data. And then, given the firm is so diverse in terms of the practice areas, we have healthcare specialists. We also have, people that are auditors, internal auditors, and the auditors play a big role in a lot of these matters. And in that respect, we have a good feel for compliance and, where compliance may have broke down, or even proactively on other clients where they can stay out of trouble if they have effective type compliance programs around FCA type issues.
Thank you, Chris. And with the government able to, particularly through extrapolation, reach numbers in excess of $100 million, at least initially, if not well beyond in these cases, getting experts involved early, I certainly recommend. You have a gut level, you can go in and say, this just can't be right, and you get that expert.